I'm Neil Hamilton, a professor of law and director of the Agricultural Law Center at Drake University in Des Moines. I want to welcome you to another installment in our series, Law for Landowners, 10 Things You Should Know. Today our subject is land use law in Iowa. The first point to remember is that your land may well be subject to zoning depending on where it's located and whether the county or city that you're nearby has enacted a zoning ordinance. Over 2/3 of Iowa's counties have enacted county zoning. The second point to remember is that county zoning in Iowa, Chapter 335 of the Code, includes an important agricultural exemption. Under this provision, most agricultural uses are exempt from zoning laws, such as a requirement that you get a permit before you could build a machine shed. This provision means that as long as what you're doing on your land relates to farming and agricultural uses, you'll be exempt from the application of county zoning. The third point is that the agricultural exemption has been interpreted broadly by the courts. The agricultural exemption has been subject to many court cases, but has been broadly interpreted by the courts. This means that you'll not be required to comply with zoning. For example, you're constructing an animal confinement facility. But because many of the things that may be involved in agriculture can cause potential impacts on neighbors, it's at least important to be aware of the land use rules. The fourth point to recognize is that the law giving cities the power to zone does not include an exemption for agricultural uses, and farms can become subject to municipal zoning in several ways. This can happen either through annexation, such as when a city's boundaries change by its growing, or under a provision of Iowa law called extraterritorial reach. This gives cities the authority to apply their zoning rules to any activity within 2 miles of the city limits. This is why it's important to stay aware of what may be happening concerning the growth of nearby cities and the possible changes in zoning rules. A fifth point to recognize that if current farming activities might somehow become subject to zoning, such as through annexation or a rule change, most farming activities would be grandfathered in or allowed to continue as non-conforming uses, which means they're allowed to continue, but any new expansion or changes may be subject to restriction. Farming uses may also come under scrutiny, particularly if you have new neighbors, such as if residential development happens in your area. Sixth, if zoning does apply to your property, it's important to understand how the zoning process typically works. First, the land will be mapped into different districts, such as agricultural or residential or commercial, and then within each district, the ordinance will establish principal permitted uses and accessory uses that are allowed, as well as provide other detailed rules and guidelines for the use of property. Seventh, the zoning ordinance is developed by a local planning and zoning commission, which holds public hearings and develops a comprehensive plan. The actual zoning ordinance is designed to implement the plan. The zoning ordinance itself is enacted by the local political body, either the city council or the county board of supervisors, and can be changed and amended by that body. The eighth point to remember is that once a zoning ordinance is in place, most of the legal and political activity that happens concerning zoning relates to landowners applying to try to receive some flexibility to allow changes in how their property is used and to provide some relief from the application of the zoning rules. So, for example, they can apply for a variance or some other form of relief to allow them to do what they would like to do with their property. Zoning ordinances may include several different provisions or methods whereby the rules can be changed for an individual landowner, such as by applying for a variance or an exception or various forms of administrative relief. In this way, the zoning rules can be made more flexible to accommodate landowners' desires as long as they're reasonable and don't cause impact on the neighbors. The ninth point to recognize is that most of these decisions to allow a landowner to make some use of their property other than it would be allowed under a strict interpretation of the zoning rules, those decisions are made by the Board of Adjustment. The Board of Adjustment is an appointed committee. It's appointed by the local political body, and they're given the authority to implement these various forms of relief, such as variances. The 10th and final point to recognize is that to obtain relief from the Board of Adjustment, a landowner has to apply, and the board will provide notice to the neighboring landowners and hold a public hearing on what's being requested. After the public hearing, the Board of Adjustment can decide to either grant or deny the landowner's request. Decisions of the Board of Adjustment can be appealed to the district court. As a general rule, neighbors are often happy with the current zoning and can be expected to potentially oppose any request for a change. This is why it's important for landowners who are desiring to make a change in how their property may be used to communicate with the neighbors and to try to get their support. The other major way that zoning rules can be changed is by an amendment, which can be made by the political body, such as the City Council or the Board of Supervisors.